Good morning, everyone. Can we just give it a little bit, 5 minutes, as people are still registering? Good morning, everyone. I see people are still logging in. Those that log in after we have started, we'll send them the webinar recording. My name is Tunila Ngosi, the conference producer for the Data Privacy and Protection Conference. It is a pleasure to have you with us this morning, and thank you for joining us with this weather, the undecided weather, the South African weather. Today's session is part of our final webinar series leading up to the Data Privacy and Protection Conference that's taking place on the 28th and 29th January 2026. I believe we've had a very incredible journey leading up to the main event with today's session. I believe you guys will find it very insightful and impactful. And please do engage. I encourage you to engage in the chats, share your thoughts. Feel free to post your questions throughout the session. The session will be moderated by Taz Chikwakwata from Cybernesses. He's the managing consultant in Zimbabwe, alongside an excellent panel of speakers whom Taz will introduce shortly. Thank you, Taz. I give it to you.
Thank you, Tanila, and good day, everyone. Really happy to have you all here. And as Tanila mentioned, I'm really honored to welcome you to this Data Protection and Privacy Conference 2026 pre-conference webinar. The webinar is titled Data Accountability and Third-Party Risk. Who owns the breach? As organizations expand their digital ecosystems, third-party networks have become both an advantage and, unfortunately, a vulnerability. Studies consistently show that some of the most destructive breaches in recent years originated not from within the organization, but from vendors, service providers, and other supply chain partners. Today's conversation focuses on one critical challenge. When the breach occurs outside your walls, who truly owns the risk? We will explore accountability frameworks, legal exposure, incident response coordination, and lessons from real world cases. bringing together perspectives from the privacy, legal, security, and regulation. Joining us today, we have an exceptional panel. I'll ask you to turn your cameras on during the introductions and allow me to begin with Farah Khan, Access Bank's Data Privacy Officer and Deputy Information Officer, a global privacy lawyer with deep expertise building privacy programs across multiple jurisdictions. If you don't mind just waving like this, Farah. Thank you.
Good morning.
Lise Delahab, Senior Legal Advisor at Sanlam Corporate, specializing in pension law, regulatory compliance, and governance, and a respected lecturer at the University of Cape Town. Welcome, Lise.
Morning, everyone.
Rashid Ishmael, Chief Information Security Officer at Access Bank South Africa, leading cyber governance and third-party security strategy across the African region. In true security spirit, Rashid's camera is not enabled to work, so please kindly bear with us. Finally, Lucinda Steenkamp, Senior Legal Advisor and Deputy Information Officer at CIPC, contributing to national corporate transparency and regulatory compliance frameworks. Hi, Lucinda.
Good morning, everybody.
Thank you all for joining us. Let's get straight into round one. Third-party ecosystems have become the new battleground for cyber breaches. Round one focuses on accountability, legally, operationally, and from a regulatory viewpoint. Farah, given your experience implementing programs across several regions, where do multinational organizations most often get accountability wrong when outsourcing data processing?
Thank you for the question, Taz, and I think it's a great point of departure. And as rudimentary as it might sound, oftentimes the gap really is in awareness of the inherent risks that are posed by outsourcing. And when that awareness is not there, then you see third-party privacy risk being omitted from enterprise risk management frameworks. And so you start off at that point of creating that awareness in terms of what the impact really can be down the line, right? When the requisite steps are not taken. Once that awareness is embedded, there are three critical additional awareness gaps that are oftentimes noted. And it starts off pretty simple with a what, a who, and a how. And the what speaks to, and you've said it in your question, what is actually being done is the outsourcing of data processing. Whereas under the commercial lens, the way it's viewed is that outsourcing, and rightfully so, is of tremendous commercial value. Oftentimes it forms part of digital transformation strategies. However, it's critical to look at it under the data privacy lens, because then it becomes critical that what you're actually doing is you're outsourcing data processing. So that's processing operations that would have otherwise been conducted within your environment. You're outsourcing that to a third party. So that understanding and awareness becomes critical. From there, one then looks at creating awareness around the who, right? So who's who in the picture? And this is where privacy frameworks such as the GDPR, such as POPIA in South Africa become crucial, because there are roles embedded within those pieces of legislation. So when you look at the GDPR, you have your controller and you have your processor. When you look at POPIA, you have your responsible party and your operator. In traditional service provider models, the organization, with barring a few exceptions, the organization that conducts the outsourcing or that appoints a service provider generally is determining how and why information is processed. And therefore, they act as the controller or the responsible party. That then makes it clear that accountability can never be transferred. It can never be outsourced. It remains vested in the organization that acts as the controller or responsible party. And that's a critical gap that I've seen is understanding the legal implication of that, because the legal implication is that you remain as accountable for the processing that happens downstream in the supply chain. From there, the question then becomes, if I recognize the importance of third-party risk management, and I recognize my role, how do I effectively discharge that obligation to remain accountable? And the first key aspect is actually understanding at a granular level what data processing is being outsourced and understanding how broadly data privacy laws define processing. Something like storage is processing. And so it becomes critical to actually understand what are the data flows, what are the data sets that we're sharing, how are we securing that process. And then, of course, it becomes critical to understand that accountability starts at inception. And oftentimes, the challenge that you see that organizations face is that data privacy and accountability in that context is oftentimes trying to be bolted on after the fact. But accountability starts at inception. It should inform vendor selection, and so it should be part of the RFP selection process, and it should then flow through contracting, onboarding, and vendor management throughout the life cycle of the engagement. And once you have these fundamentals in place, organizations are then well positioned to actually derive value from outsourcing without inheriting risk that oftentimes remains dormant until something breaks. And we see this with the rise in zero-day exploits and attacks. So those are the fundamental gaps that organizations really need to bridge.
Thank you. Thank you. I love what you mentioned about awareness, and you broke it down so well to say what, who, and how. But the biggest takeaway for me, and it almost sounds scary when you hear someone say that accountability cannot be outsourced. It's true, but when you think about it, it's like, we've got all of this commercial upscaling from outsourcing, but we cannot outsource accountability. Thank you for that. Let's move on to Lise. The pension sector has long depended on outsourced administrators, which makes your perspective especially critical here. When a vendor error comprises fund members' information, where does liability, typically fall from a governance and fiduciary perspective?
That is indeed a high risk in a pension fund space, because as you said, it is quite usual for a fund to outsource its administration because of the fact that obviously the administrator would have the necessary systems to actually administer benefit payments, et cetera, et cetera. So trustees, I mean, the very purpose, the object of a fund is to provide retirement benefits to its members or death benefits to dependents. So the trustees in administering these funds assets are actually acting in a fiduciary capacity, obviously because it's not their own money. So the Pension Funds Act sets very specific duties on boards of trustees in pursuing this objective. And that includes not only acting in good faith, having a fiduciary duty, but also protecting members' interests at all times, and importantly, ensuring that the fund is administered in accordance with the law, as well as the rules of the fund. Now, the increasing trend of you seeing trustees being held personally liable for damages that's caused by maladministration of the fund, that obviously just adds the whole concept of cybersecurity, data privacy, all of that as a significant burden on an already significant burdensome role. So we know in terms of the Protection of Personal Information Act, which obviously applies to retirement funds as responsible parties as well, that the fund will remain accountable for any breach that occurs either by its administrator or any other service provider that in the context of this act, of course, is an operator. And that is why it is so important to make sure that the service level agreements between the fund and these service providers not only cover all the operator requirements set out in the Act, but also sufficiently have warranties and indemnities and all of that to cover them for when something goes wrong.
Fantastic, thank you. I love what you mentioned about the SLAs, and all too often we've done so many of them that it's so easy just to let them, whatever, it's run of the mill thing. But when you start talking about personal liability, it hits home and it hits hard. So I think that's a very good point. Thank you. And just to the audience, if we have any questions, please, we will have a Q&A session. If you can pop those into the chat or the Q&A. I know as our experts start to unpack this, there may be quite a few situations where you want to ask a question. Please put that into the chat box or the Q&A, and we will be certain to follow it up if we have the time. Over to you, Rashid. Looking at the numbers from IBM, the cost escalation in third-party incidents is absolutely striking. The IBM 2024 cost of a breach report in particular shows third-party breaches cost 11% more on average than internal breaches. From a security perspective, why do third-party incidents escalate costs so significantly?
The 11% attribution in the higher cost spans several factors. Some of these factors include an extended surface attack, meaning that based on the expansion of the supply chain and infrastructure becomes vast, and it creates an additional layer of complexity. And due to the complexity, it makes it more difficult to identify the breach. In addition to that, we have our third parties that either have limited tool sets for detection and response, which makes them more of a targeted victim and more challenging in identifying or resolving the type of breach. The other factor is based on regulatory issues where we should consider cross-border agreements, data transfers, the investigation capabilities across these third parties in considering the regulatory requirements for administration of those remote systems, which creates a even greater challenge. In addition to that, we have a principle that's called supply chain ripple effect. We've often seen that when one supply chain gets compromised, their fourth party or fifth parties get impacted at the same time. And considering this complexity, it increases the cost in terms of remediation, resolving, and the impact across the entire supply chain.
Thank you very much, Rashid. You know, when you mentioned, I think in the first opening statement that when you obviously engage third parties, you've extended the surface attack. And the statement that came to my mind was the bigger they are, the harder they fall. And honestly, obviously, when you now spread your tech across a lot of different platforms, the exposure is much greater. So yeah, very, very interesting insights, as well as the supply chain ripple effect that you've just spoken about. Thank you. Moving on to Lucinda. Excuse me. From a regulator's lens, digitalization brings enormous benefits, but also new oversight challenges. What risks concern regulators most about third-party technology vendors processing sensitive corporate filings and beneficial ownership data?
Thank you very much, Taz, for everybody on our discussion. Excuse me for not switching on my camera, but I see this weather is affecting my network, so I just don't want to get lost in translation. So as more and more data is generated and stored digitally within the CIPC, the risk of data exposure from breaches and cybersecurity attacks increase. The risk associated with the use of third-party service providers includes greater interdependencies and compliance complexities in terms of the storing and generation of data. In the process of performing its functions, though, the Commission has no choice but to make use of service providers, aiding in the processing of data, which increases operational, financial, reputational, and regulatory risks. To name a few, cybersecurity, first off, venturing into data sharing through APIs and other integrated devices broaden the landscape for cyber attacks. Third parties may be viewed as the weaker link to breach an organization such as the CIPC, which has a more secure network. Data privacy is another. Although the CIPC registers are open and available to the public, certain aspects of its corporate registers contain confidential information, such as the beneficial ownership register. One of the considerations for developing the CIPC's BO register in-house was data privacy and that interdependencies and complexities of third-party operators. Operational disruption is another. Any reliance on third-party vendors in the performance of digital functions can cause disruption of critical operations and processes in the event of a power outage, service failures, and more. An example that I can provide is the Commission's real-time link with the Department of Home Affairs. If there is a situation on the side of DHA, most of our operations are impacted because of the identity validation that is required in real time when processing. Another one that's very important is the regulatory scrutiny. The The Digital Operational Resilience Act, DORA, provides for explicit requirements to manage third-party ICT risks effectively. And it is important for any body that applies third-party service providers and vendors to make sure that the requirements in terms of ICT risks and cybersecurity are effectively applied, that the ones that are appointed to process data to enhance systems and structures comply with those requirements. Thank you.
Thank you, Lucinda. And it's so sobering to hear you mention that the beneficial ownership register was particularly developed in-house in lieu or with regard to data protection concerns. So well done to you and hats off to the CIPC. That brings us to the end of round one. And in round two, we shift to the practical side. Risk assessments, ongoing monitoring, and incident response when the breach starts outside your organization's perimeter. Once again, we'll start again with Farah. Continuous monitoring is still a gap for most organizations from a compliance perspective. According to Deloitte's 2024 third-party risk management survey, 57% of organizations do not have continuous monitoring of third-party risks. From a data protection officer standpoint, what minimum ongoing monitoring should be considered reasonable under POPIA or the GDPR?
Thank you, Taz. I think what is critical to understand about privacy laws at large, and then particularly if we look at the GDPR and POPIA, is that by and large, they're principle-based laws, which means they set out a framework of principles that organizations that then have to embed right within their data protection frameworks. And essentially, this means that any ongoing monitoring model has to be in line with being able to demonstrate that you meet those principles and that your ongoing monitoring approach is in line with that. So a simple question would be, does the way in which I monitor my vendors actually demonstrate that I maintain accountability throughout the supply chain? So that's the first principle-based aspect to understand when considering ongoing monitoring. Then, of course, one has to note that there's no one size fits all when it comes to ongoing monitoring, when it comes to vendor management. Ideally, what you would want is for your vendors to be risk rated and to have risk profiles. And then you tailor your ongoing monitoring approach to your vendor risk ratings. Your rule of thumb is generally to ensure that your ongoing monitoring puts you in a position to be proactive rather than reactive, because vendor risk is not static. And so if all you're relying on is that initial posture, be it from a security or privacy perspective, if you're relying on the onboarding posture, essentially all you've got is a snapshot in time, right? And so in today's day and age, with the advent of technology, we have phenomenal intelligence-based continuous monitoring capabilities that rely on data analytics, and that gives you a real-time live insight into the way that risk environment as it relates to a vendor changes. But even organizations that have a more modest budget, for me, there are fundamental underpinnings of ongoing monitoring that can be implemented. So the first departure point is, when is the precedent set for ongoing monitoring? And that is at onboarding. That is your first opportunity to bed down with your vendors the level of cooperation that you expect through the course of that vendor relationship. And oftentimes, if you see vendors behaving badly, it's generally because that hasn't been bedded down at inception. And so when you started through the process, you oftentimes met with resistance. So that's the first, departure point for ongoing monitoring. Thereafter, it's critical to, whether it's automated or if it has to be manual due to budget constraints, it's critical to have an ongoing review, testing, and audit process. And this oftentimes happens through ongoing inspections, periodic questionnaire-based audits, And it's important for that exercise to be carried out periodically. It's not a once-off. And obviously the frequency would depend on the risk profile of the vendor, right? And how critical or high risk the vendor is, the nature of the data processing conducted by that vendor. And so it's crucial that you are reassessing risk on a continuous basis. And it must be evidence-based. Like I said, when you rely on self-reporting, it's very difficult to leave it at that point and then have a robust overview of what's actually happening in the vendor's risk landscape, right? And so one has to ask, my ongoing monitoring, be it automated, be it manual, there are certain big ticket items that you need to be covering as part of your ongoing monitoring on a periodic basis. The first is incident response capabilities, right? It's critical, and we'll get to sort of the contractual components of that, but it's critical to assess whether your vendors are au fait with what's required in the scenario of an incident. One has to also ensure that from a negative news monitoring perspective, organizations are keeping a track of litigation, enforcement actions, because those are very telling of the risk environment that a vendor is operating within. It also becomes critical to, as part of that process, also understand changes in the service model, changes in the commercial strategy of a vendor. Because if you look at emerging technologies like AI, you've seen that being integrated into service models very frequently, right? And so it becomes an emerging risk that ongoing monitoring needs to keep up with. And then, of course, that ongoing monitoring process has to look into the management of fourth party risks. Are our vendors maintaining the same certifications, ISO certifications, SOC 2 attestations that they did at onboarding when we thought, that the risk profile was low? Are those being maintained? And so those are a few of, the key aspects that should be built into that ongoing monitoring, periodic reassessment. But again, ongoing monitoring is only as effective as remediating the vulnerabilities and the gaps that are found, right? Otherwise, it's almost a very simplistic exercise and a very superficial exercise. So that's where the second leg of the ongoing monitoring and the actual remediation comes in. Are we amending, modifying, testing our controls? Do we need controls to be more robust? How are we approaching this new risk profile? And actually addressing the gaps and the areas of concern. And of course, managing emerging risks as well. Thank you.
Lovely, thank you. I like how you approached the risk dynamism, that it's not static at all, and the need to have risk ratings and risk profiling for proactive management. Thank you for that very holistic answer. Let's move on to Lizelle. You interact closely with boards and trustees, so I can only imagine training and competence forms a big part of your world. Should pension fund trustees be trained on cyber and third-party risk, given the rising regulatory scrutiny? If yes, what minimum competencies should they have?
Well, the answer is short and sweet. Absolutely, yes. As I mentioned earlier, for the very nature of their position, trustees act in a fiduciary capacity. So it's critical that they have the appropriate qualifications or experience to deal with the complexities that surround pension funds, which of course includes, in this day and age, your cybersecurity. Now, board members, in that sense, the way the Pension Funds Act is worded is actually, it's part of their duty to know what is expected of them, to act as a trustee and to make sure that the fund is administered properly. And the importance of trustee training, as well as education and appropriate levels of skill, is actually highlighted in the Pension Funds Act itself in Section 7, where it says that board members must attain levels of skills and training as may be prescribed by the FSCA. Currently, that is the FSCA toolkit, but that also doesn't mean that that's it. Once you've done the toolkit, the FSCA toolkit, that's all you need to know. You have to stay abreast of legal developments. So as new risks emerge, you'll definitely have to undergo training, because the human error still remains a big risk, especially in the context of if you think of your independent trustees. Often this will not be trustees working for, let's say, the sponsor that actually have company issued laptops, automatic malware, all of that, cybersecurity policies that all staff are bound by. This could be your external trustee sitting somewhere with their own personal laptop that might not be updating their malware. I'm not an IT guy, I don't want to go into that kind of stuff. But all the things that where if you work at a corporate, the IT guys worry about that, you don't, kind of a thing. So it's very important to cover that kind of stuff and actually to build it into your governance policies, your codes of conduct, etc., to make sure that trustees not only remember that, but are actually bound by that. And in there, I would include something like it is expected of you to have ongoing training, because all these skills and expertise that you have to have is not only to join the fund, you must maintain that while you are a trustee. Also, the FSCA last year published the FCA and the Prudential Authority, which are the regulators that regulate my industry, published a joint standard on cybersecurity, which came into effect in June of this year, that sets up very detailed requirements for sound practices and processes specifically relating to cybersecurity. And one of the requirements is that the Board of Trustees must establish and maintain a cybersecurity strategy and framework. Now, if you think about that, you're not going to be able to do something like that if you don't actually have adequate knowledge. And most trustees are not IT specialists, so you'll need to undergo training. So also remember, the Pension Funds Act actually says that it's part of the duties of trustees that where they don't have sufficient expertise for a particular something, they have to obtain expert advice. So you'll have to go and consult with either cybersecurity lawyers or IT specialists, if I can put it that way, and then undergo the necessary training. So there isn't a specific what qualification, certification that I can recommend, but so I've answered it more from the other way around of whatever you choose, make sure that you are going to be able to say that you are sufficiently meeting all your duties as imposed by the Pension Funds Act.
Fantastic. As a cybersecurity consultant and trainer, I fully endorse that response. Thank you. And it's music to my ears. Yeah, I think all too often, it's taken like a tick box, but it's actually real issues. So to hear you speak so passionately about them is really, really heartwarming. Over to you, Rashid. Rashid, Verizon's 2024 data breach investigations report highlights that external parties disclosed 72% of third-party breaches before the affected company even became aware. What does this say about monitoring maturity, and how can CISOs improve visibility across vendor environments? Rashid, if you are speaking, you are muted.
The maturity level on those are often low, and those factors are highlighted through the means in which the organization either identifies or detects that they've been breached. The channels normally are either through the customer, the media, or the regulator. This then implies that the organization hasn't got sufficient monitoring tools to detect the incident and respond to that incident as it occurs. From a third-party perspective, we find that there's a lack in terms of integration into third parties, where we cannot monitor third-party environments. Through strengthening the external monitoring or integration, for example, if we could integrate our SIEMs into our third party for those anomalous events, it actually means we can strengthen our position and detect these anomalies or the incidents almost in a real time, which then can reduce the percentage of time that we actually respond to it. And then just touching on elements that Farah noted around the incident management processes. Incident management processes are not clearly articulated in the primary company or the third party, and they are not integrated. There's often miscommunication or misunderstanding in terms of how the incident should actually be responded to, which then gives an opportunity for the event not being remediated in a timely manner.
Thank you, Rashid. And the unfortunate thing is that I'm also a cybersecurity person, so I'm gonna follow up a bit on your response there. And also in relation to what Farah mentioned, there's multiple incident and breach management frameworks out there, from ISO 27035 to NIST SP 816. What do you feel is the best or most holistic framework that can be used within the South African context?
If you're looking at the NIST framework, NIST framework is more geared up for the American military capabilities, and it is resource intensive.
Mm-hmm.
I would recommend looking at ISO 27000 and stripping out components from NIST, the 4 pillars, and structuring your ISO 24000 around the 4 pillars of NIST, which then gives you a much more comprehensive and reactive framework that one can implement in a large or a small organization.
Fantastic, thank you. And I like the fact that what you're speaking to is regarding customization and not just taking things off the shelf, which then takes Faraz's point and puts a very practical aspect to it. Thank you, Rashid. Over to you, Lucinda. Organizations often underestimate how much oversight regulators expect them to exercise over third parties. The question is this: how does the regulator view companies that outsource critical corporate compliance functions to vendors without proper monitoring structures?
Thank you, Taz. To answer that question, I'm going to take everybody back to many, many years ago. I'm sure you will all remember CIPRO, before we were the commission. In that time, for many years, the regulator at that time was faced with unscrupulous third-party vendors being used by clients to transact on platforms, CIPC or CIPRO at that time, platforms on their behalf. So other than education and awareness campaigns to communicate the dangers, our hands were tied as a regulator. We did not have and still don't have the oversight responsibility in terms of compliance requirements, corporate compliance requirements. As long as they comply with the compliance requirements of the Act, how they do that is up to them. But that situation that we experienced many years ago necessitated the requirement of strengthening security, making it as easy and as simple as possible, while still holding the security requirements in place for corporate structures to comply with requirements directly without using third-party vendors. And where that third-party requirement comes into play, and again, I'm going to make use of a practical example, is that and I know Farah indicated that accountability remains with the responsible party, is that we insist on where third-party vendors are used to provide for corporate compliance on behalf of a client, filing annual returns or submitting beneficial ownership declarations, for example, that there are signed mandates in place, pinpointing a specific natural person that accepts responsibility for the information that they are provided. And it also make it very clear on our systems that should false information be provided, they can be criminally prosecuted. So in that way, the CIPC as a regulator tries to provide for corporate structures to comply directly, because they carry the responsibility. And if they do outsource this functionality, to make sure that all their requirements are in place because they remain responsible. So recent pieces of litigation, however, such as the FIC Act, provides for accountable institution registration and stricter due diligence protocols to be followed as well, which strengthens this corporate compliance structures. Internally, to talk about a supply chain, the Commission mitigates against supply chain weaknesses. Internally, this is now our own processes by ensuring that when service providers are appointed, that there are clear contractual and service level agreements in place. This prohibits outsourcing to third-party vendors, and where prohibition is not possible, establishing explicit security expectations, the right to audit services, which has been mentioned by my fellow panel members quite extensively, and systems and termination clauses in the event of breach. So ensuring that all those contractual requirements for cybersecurity, data privacy, etc., is embedded in the service level agreements. It mitigates the possibility of throwing up your hands and saying that I'm not responsible. You signed and accepted responsibility when you accessed that service provider contract through supply chain processes. And there is a clear requirement set that the CIPC, for example, has the right to audit your services at any time to make sure that it complies with these structures. Thank you.
Thank you very much. And very interesting what you mentioned around the FIC Act, along with accountable organization registration. And I do feel that as well, it does strengthen the cause, so to speak. Thank you for that response. And with that, we'll now move on to our final discussion round. And it examines the tools organizations use to allocate and transfer risk contracts, legal safeguards, insurance, and what the future of third-party risk looks like. Once again, we'll start with Farah. Major breaches that involved supply chain attacks, such as MoveIt, SolarWinds, and payroll system hacks, affected organizations globally despite robust internal controls. What is one major lesson privacy officers should take from these incidents when structuring third-party agreements?
Thank you, Taz. I think it's a pertinent question, and particularly if you look at these supply chain attacks or any sort of data breach that transpires that involves a third party. Oftentimes people would look to the contract, right? What are our contractual safeguards? And when that has not been structured correctly, you are left with very limited recourse. Now, I'm going to preface what I'm going to talk about in the contract structuring segment by saying it's also important to understand when you approach contracting, particularly from a data privacy standpoint, to understand the privacy laws that apply. Because if you look at the GDPR, and similarly, if you look at POPIA, certain contractual protections are mandated. Controllers are required to have data processing agreements that set out, Lucinda mentioned a number of them, that set out critical aspects that should be taken accountability for by the third party in the event of incidents and supply chain attacks. So what becomes a crucial lesson in this context is understanding that regardless of your own efforts to secure your internal security posture and privacy posture, all of those efforts are very quickly undone by third-party risks that are left unmitigated. And third-party risk mitigation therefore hinges on strong contractual safeguards. And if we look at what do strong or robust contractual safeguards look like, DPAs should, in essence, form the guardrails for your engagement with a vendor from a data privacy standpoint. And so a key aspect to build in a contractual perspective is data breach notification. And it shouldn't be sort of superficial language that says that a vendor should notify the customer as soon as possible. That's not robust enough to actually give you recourse, right? So if you look at the GDPR, it says that processes need to notify controllers without undue delay. POPIA says that that operators are to notify responsible parties immediately. That kind of language with a vendor in instances when a breach has happened becomes problematic. And so from a contract structuring perspective, you should introduce timelines. And depending on the nature of the vendor, generally 24 hours, you need to ensure contractually that they are mandated and contractually bound to provide that notification. But then that notification on its own is insufficient. So are you building out breach notification clauses in your contracts that actually set out the format and content of those notifications. Because what's important is generally, and particularly under privacy laws, it's the controller or responsible party that is liable to attend to regulatory notifications. But then you have a dependency on the third party service provider. And so it's critical to set out what that notification should include: scope, scale, data subjects impacted, costs of remediation. Costs becomes a critical component, and it needs to be very clear who bears the costs for various, Rashid mentioned the rising cost of data breaches that are caused by third parties. And so having those cost allocation mechanisms becomes absolutely critical. Building in daily progress updates as the data breach remediation goes on becomes important. Lucinda mentioned having security standards embedded within data processing agreements. Various privacy laws set out their own requirements in terms of criteria that security standards should meet. And it's important to take into account the nature of the vendor. Do we expect the vendor to conduct continuous or periodic pen testing? It also is important from a fourth party risk management perspective to assess from a contractual standpoint, how do you approach subcontracting? Are vendors allowed or not allowed to subcontract certain aspects of the services that they render to you? If they're allowed to, what does that model look like? Are you providing general authorization for them to appoint subcontractors? Do you want a specific authorization for each contractor where you provide consent for that contractor to be used? That becomes critical in managing fourth party risk, which becomes quite relevant in supply chain attacks, because you see the impact of fourth party risks that are essentially that materialize. And then of course, liability and indemnification. It is so critical from a contracting standpoint to assess how that language is constructed. Vendors have a tendency of trying to limit their liability, but it becomes prudent to ensure that your contracts designate liability and indemnification accordingly, because those costs rack up. Regulatory penalties come into the fore depending on the nature of the data breach. And so you want to ensure that vendors are not attempting to unduly limit their liability. And then Lucinda, of course, mentioned the right to audit. It becomes so critical. And so your contracting component, ensuring that you take a robust approach, ensures that should a data breach happen, it can be dealt with in a far more streamlined manner that can, reduce costs and of course reputational damage. And so contractual provisions are absolutely pertinent in ensuring that you are forward thinking and anticipatory in your preparation for data breaches, which unfortunately in our digital landscape have become a part of the reality.
Yeah, thank you very much. And uh, part of the reality and almost inevitable sometimes. I like what you mentioned initially around understanding applicable laws. And I think this is so um, very necessary for organizations that have a large berth in terms of their footprint, especially digital platforms. South Africa has done incredibly well in terms of having platforms that are across Africa. And if you don't understand the laws in those jurisdictions, it can become a problem. I mean, you spoke about GDPR, and now we've got the UK pulling out the UK GDPR that's separate. Zimbabwe is coming up with the CDPA, and they're very specific about their breach notification is 24 hours. The Nigerian NDPA is 72 hours. Kenya is similar to Papua, as soon as possible. So if you just have your stuff set out properly, it really gives you a good base. So thank you for that response. Appreciate it. Let's move on to Lizem. Contract language often determines who absorbs the real world impact when things go wrong. In your experience, which contractual clauses are most effective in allocating liability for third party breaches? Indemnities, service levels, warranties, or audit rights? And which of these are often misunderstood by business teams?
I'm gonna on this one keep my answer brief because I think Farah's pretty much said everything that I was going to
Yeah.
list here. But maybe I'll answer it more from a fund perspective. So as I said earlier as well, the funds will ultimately be responsible for, remain accountable for any kind of a breach that occurs by an operator, and that's why the service level agreements are so important. And I mean, we know that the Protection of Personal Information Act sets out very specific requirements that have to be covered in your operator agreements, one of which is that appropriate security measures must be put in place to prevent loss, damage, unauthorized access, and therefore it is an incredibly important term that she also touched on about notification of breach, because the fund as the responsible party will have to notify the data subject and the information regulator as soon as possible. So the act actually refers to as soon as reasonably possible, but at the Pension Lawyers Association annual conference last year, the information regulator was a speaker. And he actually said that in his office's view, they want to know about a breach in at least 72 hours, because that's in line also with the Cybercrimes Act. So he suggested actually that funds ensure that their operator agreements make provision for immediate notification. Now, I know that as an attorney, the first thing when you see the word immediate in a contract, you go back and you replace it with as soon as reasonably possible. But here, if you consider the expectation from the regulator, you have to build in time to know about a breach that occurred somewhere else, and still, once you now know about that, be able to report it within what the expected timelines. So it's incredibly important to make sure that your contracts do actually make provision for immediate notification and then assistance, because as Farah also said, you actually have to, that security compromise notification, you have to explain what happened, who was impacted, what can the data subject do to maybe mitigate, from their side, what are you going to put in place or do, or what have you already done to make sure this doesn't happen again? So you need a lot of information. And that is obviously also important then, that why the agreements have to make proper provision for warranties as well as indemnities to because obviously error can happen, and there can be significant fines imposed on, never mind the reputational damage. And also another important thing is to make sure that your I know what we do from my side is we make sure that our third party operators, that they have adequate cybersecurity indemnity insurance in place, and we ask for proof of that. Lastly, another one just that none of the other speakers have spoken to is, it's also, we know in terms of the Protection of Personal Information Act, you are allowed to send personal information cross-border, but there's when dealing with foreign contracting parties. But of course, there, it's also very limited in the sense of you can only do so if it meets the requirements of Section 72 of this Act. One of them being that third party is then subject to either a law that's similar to ours when it comes to data privacy, or that at least that there's binding corporate rules or a binding agreement in place in terms of which you then bind that third party foreign service provider to the same principles to uphold the conditions set out in our legislation. So therefore, especially when a fund is dealing with a foreign contracting party, it's incredibly important to make sure that the SLAs properly cover these requirements with relation to cross-border transfer as well. So although it's allowed in terms of the Act, that again poses a bigger risk when contracting with these foreign parties, especially where they don't have similar data privacy laws, which is still possible then, as long as you have a contract with them, etc., etc. But that's when the wording of your contract, making sure that it is really properly, tightly worded, becomes even more important.
Thank you. And thank you for touching on the points, like you mentioned, the other presenters have not looked at. What I also liked from your response is the sector-specific considerations to say, listen, the information regulator said this, the law says this, but the person who's going to fine us is saying this.
Exactly.
You must consider
Yeah.
those things. I think
Exactly.
it's always incredibly important. So thank you very much for that. I can see we have a question from Peter. Peter, we're almost done with this round, and we'll really come back to your question. With that, allow me to ask the final two questions, and then we'll open up to questions from Peter as well. So over to you, Rashid. Insurance often appears to be the safety net, but the clauses can be quite tricky. Where do you see the biggest gaps in vendor cyber insurance clauses that companies routinely overlook?
Thanks, Taz. I think the challenging component or oversight, we normally believe that one policy fits all. Our contractual agreements are not considered, which then creates gaps in the coverage from a control perspective. We sign up one insurance policy to cover multiple vendor types, while the vendor maturity levels in terms of their controls are not adequate. And as such, there's a perception that the coverage is sufficient. And with these poor controls, we find that the premiums either rise and the coverage decreases because our third-party vendors do not have the adequate controls in place. In addition to that, we have limited oversight and providing the adequate assurance that our third parties have sufficient controls in place. This is where we find ourselves with a blind spot. And when it's time to actually put in the claim, we then realize that the cover hasn't considered reputational damage, it hasn't considered penalties, etc. And as such, we find that we then can't recover adequately from the policy.
I like that response. And it took me back to yesterday when I was attending another conference, and there was a cybersecurity auditor that was on a similar panel, and she was absolutely livid. She was complaining about the fact that cyber insurance will often have very specific tick boxes. For example, looking at your asset registry, do you have encrypted hard drives? Yes or no? But especially like the way you put it, Rashid, limited oversight to your third party. How are you supposed to make sure that a third party that has maybe 1,000 employees and maybe 2,000 hard drives, that each one of those, yes or no, is encrypted? It's almost impossible. So that speaks exactly to what you're saying. Thank you very much, Rashid. On to our final question for our regulator to wrap up before we open up the floor. Lucinda, globally, we're seeing a shift toward more prescriptive oversight of third-party ecosystems, with global trends pushing for greater transparency and breach reporting. Do you anticipate stricter reporting obligations or mandatory vendor audits emerging in the next regulatory cycle?
Thank you, Taz. I'm going to echo what Lisa indicated earlier. Absolutely. The General Data Protection Regulation, the GDPR, and the Protection of Personal Information Acts, all of those are pieces of legislation that ensure compliance with data privacy and security laws. However, with the greater transparency being pushed through globally, as you indicated, I'm going to borrow from Spider-Man that says, with great power comes great responsibility. The same applies here. With greater transparency comes greater responsibility. And the only way to ensure the compliance with data protection guidelines and laws is through the enforcement of mandatory audits of service providers and vendors as it relates to cybersecurity and data protection compliance. So absolutely, from a regulatory perspective, I think that that is definitely the trend in which our corporate environment will move, where these types of audits will not be selective, but will actually be mandatory if you want to participate in third-party service providing or vendors, etc. So that is definitely something, and especially enforcement of those requirements where we see more breaches occurring because of transparency. And I think there's so much information out there that you won't have the situation of third-party service providers and vendors throwing up their hands and saying, I didn't know. So there must be the processes of ensuring that these guidelines is set out clearly from the onset and then enforcement thereof. Thank you very much.
Thank you. And I love the Spider-Man reference there. With great power comes great responsibility. To whom much is given, much is expected. So let's expect those mandatory audits of vendors, etc. Thank you very much. I think at this point we have reached 11 o'clock, but we will have some time for a couple of questions if necessary. And we'll open up the floor. I can see from the chat box that we have a few comments. Thank you very much, Craig, for your comments. And also concerns, like you mentioned, that the CIPC has unfortunately been a source of impersonation by criminals to conduct company takeovers linked to SARS tax claims, etc. So I think Lucinda did mention a lot about what the CIPC is doing internally as well to try and protect against these things. But the whole reason we're having these conversations is to unearth these concerns. So thank you for that. Do we have any questions from the floor? Whether in the chat box or Q&A. Okay, so someone has raised their hand again, Peter. I'm not sure, Tunile, if Peter would be able to unmute to speak. I think
Yes.
Peter would like to.
Can you hear me? Yes? Can you hear me?
Yes, we can. Yes, we
I
can. Go ahead,
can't
please.
switch on my camera, so apologies. That's been disabled. Taz, just my question on notification of security compromises as per POPIA. Once reality, once that incident happens, there's usually a lot of, how can I say, pandemonium, all sorts of things that goes on during that particular process. So the way I also read the Act insofar as notification, my understanding is I should notify as soon as reasonably possible, but I don't necessarily have to immediately notify the data subjects at that particular point, given investigation, given facts that we need to determine, etc. And for me, sometimes it's a gap, especially on the third party side, that they're not prepared for it. They don't understand what are the implications. So it's twofold. It's the actual reporting to the regulator to say this is an potential breach or potential issue, but then subject to further investigating and evidence supplied, etc., which might eventually, come out to be just an incident. Nothing really was compromised, etc., etc. What we find is that the breach happens. Let's now finish the investigation and then only re-report, which inevitably delays the reporting expectations from the regulator side. I don't know if there's any comments around that, but around notification, make sure investigation is complete and then formal notification to potentially to data subject, or as the regulator guides you to do that reporting, either direct notification, website, media, etc.
Thank you very much for that question. And I can see again, and I was actually going to say Farah or Lizzie, would you like to answer that? But I can see Farah's hand is up and Lizzie.
Yeah, maybe just as a comment from my side, I must say, Peter, I interpret it differently. I mean, if you go and have a look, where you talk about security notifications, section 22.1, the regulators subparagraph A and subsection A, and the data subject is subsection B. So there's no different timing requirements in my view. The notification is subject to when it comes to the data subject, is subject to an exclusion where you're only allowed to delay that notification to the data subject if it's actually going to impede a criminal investigation by a public body. So I know from discussions with the regulator at industry events that it's definitely a case of, even if you don't have all the information just yet, you must notify, and you can always undertake that you'll then go back and give more information.
Yeah, and I agree. And let's maybe I look at section 2 and 3 as well under section 22, and it's Lisa's almost to say notify immediately or as soon as you become aware, right?
Yeah, because the thing is, you want to give the data subject the opportunity to, if there's something they can do, like, if there's been an unauthorized access to a bank account, whatever, to at least try and go and, maybe block the account with your bank so long or something, because that's the whole purpose. I think that's when you need to zoom out and think, what are you actually trying to achieve with notifying the data subject?
And also the context, exactly to your point, is there immediate threat to the data subject?
Yes.
If there's not, sort of it's context matters in that case.
Definitely
as well.
much. Yeah, very much. Yeah.
Thank you very much, guys. And apologies, my one device had just gone off for some reason. Farah, please come through.
Thank you. Thank you, Taz. And thank you, Peter. I think it's really it is a balancing act a little bit because and I think in so long as Section 22 doesn't prescribe a timeline, the reality is organizations are going to take a context-based approach. My view is that best practice is generally to provide that initial notification because to the point that's been made by my fellow panelists, what you're trying to achieve is safeguarding the data subject. And oftentimes they need to be able to take remedial actions. I do think, though, when you look at the language in Section 22, sub 2, there are certain exceptions that say, it must be made as soon as reasonably possible after the discovery of the compromise, taking into account, certain aspects. And one of those is legitimate needs of law enforcement, but also determining scope and restoring integrity to any systems that have been compromised. And I think what's crucial, depending on, the way that an organization opts to interpret these provisions is if there has been a delay. And I think we see this in the online reporting portal of the information regulator is being able to justify that delay. So I think, like I said, I think best practice is as soon as reasonably possible, once you have something that's intelligible and reasonable and relevant to communicate, I do think initiating that conversation, certainly from my engagements with the information regulator, is in line with what is expected under POPIA. But to the extent that there are delays, I think being able to demonstrate the rationale becomes critical. And to show that that delay was for proper cause and didn't actually, impede on the rights of the data subject. So yes, but I certainly think that the information regulator's position is to provide it, as soon as possible, and then supplement, thereafter.
Thank you. Thank you, Farah. Thank you, Lise. And thank you, Peter, for that. I think one other thing just to add is that it's so important to have a relationship of some sort with your regulator, to be able to have those formal and informal conversations and understand where they're taking things. Because the notification obviously has to be formal, but if you have a relationship, it's always easy just to let people know, listen, something could be happening here and we'll let you know shortly, rather than being in that uncomfortable space of failing to notify on time. So thank you very much for those responses. Do we have any more questions? We may be able to take one more if we have any. If not, thank you very much. We've had a rich and insightful discussion today. And what's clear is that accountability for third-party breaches is not a single owner issue. It's shared between controllers, processors, and regulators. I want to sincerely thank our panelists, Farah, Lise, Rashid, and Lucinda, for sharing their thought leadership and expertise, and to all our attendees for joining us. As we head toward the Data Protection and Privacy Conference 2026, which will be held on the 28th to the 29th of January 2026, conversations like these will help strengthen our collective approach to data protection, governance, and digital trust across Africa. Thank you all, and we look forward to seeing you at the main conference, which will be held during the Privacy Week. So back to you, Tanile.
Thank you so much, Tez. Thank you, everybody. I hope to see you at the main conference in January. With that, I thank you. Enjoy the rest of your day.
Thanks, everyone. Bye.
Thank you very much, everybody. Bye-bye.
Thanks, everyone.
Bye.
Yes. Bye.
Thank you. Bye.